Welcome to another show of Dying in Grace, the program that makes the taboo of death and dying a normal topic to be discussed and to learn about. Our plan is to have us talk about all aspects of death and dying so that death becomes normal again in our life and is not a taboo topic. Each week we bring an expert from our community. My name is Arlene Stepputat, and if you're interested in my own journey about death and dying, or if you want to see past shows, you can go to our website, dyingingrace.com. You can follow us on Twitter, and you can also go to our YouTube station, Dying in Grace. Planning end of life, getting ourselves together for death is a challenge for most of us because we want to avoid death, so we don't want to think about anything about death and dying at all. However, wise people do make those plans. I'm happy to have tonight's expert about estate planning with us. I want to welcome Claude Dorais, attorney, retired attorney, but an estate planner. So thank you so much, estate planning attorney.
My pleasure.
Thank you so much for being here. So tell us a little bit, how many years were you in practice and how did you choose estate planning as your area of expertise?
I was in practice for 43 years. I got into estate planning when one of my partners was starting to age out of his practice, and the area interested me, mainly because of the way you help people. One of the fundamental parts about estate planning from a legal perspective is that the client has to develop a lot of trust in the lawyer. They have to be willing to tell you the things that concern them, the family issues that might become issues, the fears they have about how their assets will be handled or what will happen after they die. They have to trust you enough to tell you all those things. And then, and only then, can you really bring to bear all the tools that you have as a practitioner. So I liked the interpersonal aspect. Many of my clients over the years became good friends, and even though I retired almost a year ago, I'm still in contact with one or two clients who've become friends every week.
Beautiful. So how does someone, do they approach you and say, I'm ready to do an estate planning? Or, I mean, how did those clients first come to you? Because that reluctance to even look at death and dying can be tricky. So it's great to develop trust, but how do you start the relationship?
Well, I was very fortunate in my practice, and virtually all of our clients were either long-term clients of the firm or the children of long-term clients or the spouses of long-term clients, or they came to us by personal recommendation. It's a much better way to start a relationship than a newspaper ad or anything like that. So I had the benefit of having people that came in, they already felt they knew something about our firm and about me before they came, and we could get right down to trying to meet their needs. So that's how our business developed and grew over the years. We had many clients, I had clients that are three generations of clients in the same family.
That's lovely. So if I'm thinking about estate planning, and maybe I don't have much of an estate, but I want to make sure certain things are handled. What do I do when I come to you to help me plan? What is it that you'll help me address?
Okay. Well, there are different aspects of it. There are some parts of estate planning that have to do with your estate while you're alive. Things like durable powers of attorney. How are your affairs going to be handled if you're still alive, but you are not capable? Advanced healthcare directives, which you've already covered in another program we don't need to discuss here, but these are tools that affect your life during your life. And then there are the things that you address about what you want done after you die. It's important to look at what your assets are, not only the value of your assets, but the nature of your assets. Different tools work differently with particular types of assets. Many people think that their estates are too small for proper planning, but here in California, for example, we have a procedure that if someone dies without a will, or even with a will, their process is going to be subject to court approval. And that's a lengthy and difficult process. Well, now, if you have an asset, if your assets are less than $150,000, there are what we call summary procedures that you can use. But here in Santa Barbara, if you own a home, a condo, a home of any sort, okay? If you've got assets of any sort, $150,000 sounds like a lot of money, but when you get toward the end of your life, a lot of people have a great deal more than that. And so it's worth planning. It's worth at least, even if you think you might not have a need, it's worth an hour to sit down with somebody and make sure that that's the case. And then you can have the kind of plan that's appropriate for your circumstances. Sometimes it's as simple. I've had estate plans that are as simple as a one-page will.
So, so if I'm wanting to plan, and you mentioned this, yes, we've talked about healthcare agents for somebody to make medical decisions for me. But if I name somebody as a durable power of attorney for me, do they just make financial decisions? They can make other legal decisions. What rights do I give that person, and when do their rights kick in?
Okay, well, your agent under a durable power of attorney in California is known as the attorney in fact. Well, we can just use the word agent. Your agent under a durable power of attorney makes whatever decisions you give them the power to make in the scope of the document. Most of the time, my advice to clients was, you generally want to give the broadest possible range to your agent, because by definition, this person only acts if you are unable to act. If you can't do it and you don't give them the authority to do it, then there's a vacuum, and that can be a problem. If you're not sure you trust the agent enough to give them that authority, maybe you should keep looking for the right agent.
Right.
When somebody would come and say, I'm comfortable with them for this, but not for that, I say, well, why don't we keep looking for somebody you're comfortable with for whatever happens? Whether it's a matter of paying your credit card bills or your hospital bill, or deciding, whether you can stay in your home or not, or handling your investments, all these kinds of things. If you can't do these things, you've got to have something in place and somebody who can handle them.
So you raised a good point. When we were talking about healthcare agents, we sometimes suggest that maybe a family member is not the best person to be your healthcare agent, because they may not be able, because of emotional attachment, et cetera, to follow, taking me off a feeding tube or something, that maybe you need to find somebody else. What is your advice about having a child or your heirs? Do you do one person? Do you do a joint power? How does that work? And do you suggest to your clients that they should have their children be their agents?
Well, first off, the person who is your agent under your advanced healthcare directive is not supposed to be making decisions you wouldn't make yourself. They're supposed to be implementing the decisions you would make if you were able to make them.
Right.
So generally speaking, they should simply be doing what you would do if you were conscious and able to do it.
Right.
It's certainly appropriate to consider family or friends for these roles, but it's also important to make sure that the person who agrees to take on these roles is willing to do it, is willing to do what you want done, even if it differs from what they themselves might want, is willing to put up with family that might disagree with them about it. If you have somebody that firmly believes that all medical steps should be taken, regardless of whether the person is in a vegetative state or anything of that sort, and you ask them to pull the plug for you if the time comes, you're creating a circumstance that is going to be very difficult for them. Even if they do what you ask them to do, it may cause them a lot of internal stress. If your family believes that way, the person that goes contrary to what your family might believe might not be very welcome at the Thanksgiving dinner table the next time after you die, if they do exactly what you want done, which was pulling the plug. So fundamentally, you need to consider not only whether the person cares enough about you to follow your wishes, but whether they are personally going to be able to do that, and where they might have stress in doing that, and whether they can deal with that stress, or whether it's even fair to ask them to.
Now, is the same thing true if I wanted my son to sell the family home? Like, that's my wish. I die, I want to sell the home or donate it to a museum, make it a museum, whatever. Do you run into the same issues where the family member's like, but that's our home? Do you have those kinds of familial conflicts when you're appointing them to be your agent around the financial and the legal aspects?
You can have familial conflicts. There's no question about that. Every family has their own dynamics. Some families work them out just fine. Other families, I've seen situations, unfortunately, where after you share an estate with somebody, nobody's talking with anybody anymore. There's a saying among the legal profession that you don't really know somebody till you share an estate with them.
Wow.
Estate issues can often be the last battleground for things that started off as sibling rivalries or mother loved you best or things like this. Many people will use their children or even a grandchild, depending on the age difference, to fulfill some of these roles, being an executor under a will, a trustee under a trust, attorney-in-fact under a durable power of attorney. And oftentimes that works out fine, but it's not an automatic. People need to consider how complicated is the estate, what skills are going to be needed. There's a soft side and a hard side. These are not terms that other people use, but it's the way I've tended to look at it in estate administration. The soft side, for example, is somebody needs an advance on their estate. There's discretion, there's an interpersonal aspect that helps to know the family dynamics and the people involved. That's the soft side. The hard side is managing the money, selling the asset, things of this sort. The same skill set doesn't always come to rest in the same person. So one of the things that you want to give whomever you appoint, it's usually more difficult to find the right person for the soft side. You may either want to appoint somebody else for the hard side, what I call the hard side, the numbers side, or make it clear that they have the power to delegate that function. In terms of family dynamics, you have to, how well do your kids get along? Will they continue to get along? In terms of whether you name 1, 2, 3, whatever, you can name joint people. I always would write it the way the client ultimately decided they wanted to write it, because it's their document. But I would also advise them that, generally speaking, exercising powers jointly is more complicated than beneficial. You're
Right.
usually better to name, if you can name one person, and if they can't do it or are unwilling to do it, another person will take their place. But particularly on an advanced healthcare directive, they're implementing your choices. There's nothing to really consult about. They're implementing your choice. You don't need 2 people. You don't need to delay that process. When it comes to administering an estate, it's largely mechanical. Okay.
So it's funny because for whatever reason I'm flashing on movies where there's the reading of the will, the great.
Never happens.
It doesn't happen
No,
that way.
we don't
where
call a family in, we don't read the will.
So that's just a little drama, but it's kind of like that suspense of who's getting what. And I really appreciate what you're saying about how family dynamics can be played out in the execution of this final thing. And I think part of it is the relationship with the person who passed comes to fore. Either you're grieving or there's latent anger or a whole bunch of things that come out in that final process, which I guess is why I thought of those movie scenes,
But you bring up a good issue, and that is too, there's a pretty even split among, at least among my clientele, the people that I discuss this with, whether or not they even tell their beneficiaries about their estate plan. Some families feel strongly that they should tell their adult children what their estate plan is. Others feel it's none of their business until they die. In some families, it's a complete surprise what the estate plan is. In others, it's been discussed and known for some time. That, too, is a very individual kind of decision.
So is your counsel look at the dynamics of your family and decide? So I'm your client, and I say, Claude, I don't know whether to tell my kids or not. What do you tell me?
Well, first of all, I pass the buck and tell you ultimately you're going to have to decide that. I don't know your children the way you know your children.
Got it.
What is the family dynamic? How open have you been about those kinds of things in the past? Part of it is, what are you doing with your estate? Mm-hmm. If you're leaving everything to one child and disinheriting 2 children, that may not be a conversation you want to have
in advance. Yeah.
Especially if my interest is my client and their peace of mind.
Right.
But I also have to tell you that if somebody comes in and says, I want to leave everything to one child and disinherit the other 2, I'm going to say, why? Why is that? Because that's not, we have in the law the concept of the normal objects of your bounty. You would normally expect somebody that has, for example, 3 children to leave something to their 3 children. They may or may not choose to leave everything to the same equal amounts. I mean, one of the subtle issues that comes up in estate planning, and oftentimes people don't think about it, you'll have a family that will come in and they'll say, we have 3 children and we want to treat them all equally. One child is 25 years old and has completed college and grad school at the expense of the parents. The other child is in the middle of undergraduate school. The 3rd child is about to complete high school. And I would say to those people, well, what's equal? Is equal giving them all the same amount of money? If you give them all the same amount of money, what about the one for whom you paid 7 years of college versus the one who's at the end of high school? It's not that there's a right or wrong answer, but it's worth thinking about in terms of how do you as a parent perceive equal in that context. And oftentimes when people think about that, they'd say, you're right. I mean, my youngest child is going to be losing, if I die now, my youngest child is going to lose a child lose a parent at a more vulnerable age.
Right.
And they've got their whole college education ahead of them. realistically, they're going to get a much smaller they're going to get much less monetarily from their parents. That child is going to get much less monetarily from his or her parents than my other children got.
Well, I see really also why trust is such a key role in this, because you have to be able to have those frank conversations with people and to ask, well, why is it that you want to disinherit your daughter? And now you want to, like the first will we wrote or the first draft she was in, like what happened? And their willingness to tell you the truth. And so you really, I know sometimes we call attorneys counselors, but this is the other kind of counselor, counselor of the heart here.
I would always say to clients, if at the end of our initial session, you do not feel comfortable enough with me to have told me the things, not only what your assets are and what your goals are, but your fears and concerns about your children and your family and your estate and what might happen in the future. If you don't trust me enough, if you're not comfortable enough that you trust me enough to tell me those things, then we're probably not a good fit and you should find somebody else. Because the legal skill is an important element, there's no question. There's no substitute for legal skill when you're dealing with things like this. But that alone is not enough to do a job properly. You've got to have somebody that you trust and that you feel cares about you. Ultimately, that's what gets you up in the morning and trying to do these things. These documents are pretty dry and dusty. I mean, if you don't care about the people, there's not a lot of satisfaction in it. You really have to care about the people. And you have to feel that you're cared about by your counsel.
So what I hear is that, I mean, in a way, this is a gift for the family, your relationship. You really are looking out for the legacy of your client so that there's a smooth transition, that it's as painless as possible for the family that remains. And,
That's correct.
And that is a great comfort both for the client to know I've taken care of this, and to a degree, because I have certainly been around people where nothing was planned, and then nobody knows where the bank accounts are or the bank things. And I wanted to ask you the other side of it. If somebody came to me and said, I would like you to be my agent for my estate, before I said yes or no, particularly if it was a friend, not necessarily a family member, but as a family member too, what's the pieces of information I need to know, and what are the things I need to think about before I say yes?
Okay. That's a good question to ask me, because I've not only advised a lot of executors and trustees over the years, but I've also served as an executor, as a trustee. It's not something I looked for, but sometimes it happens. And I remember one family that came in once, and the only thing the 4 kids could agree on was that they didn't want any family members doing the job.
Wow.
That's the only thing they could agree on. But that they were very much agreed on. It was, so things happen
Neutral
like
party.
that. Yes,
They need a
yes.
neutral party.
There's in that circumstance, I think you would have to ask enough information to know what's expected of you so that you could make a reasoned decision whether or not you're capable of doing it. Now, oftentimes, people will name somebody and will not necessarily tell them in advance. They will name them and not ask them, okay?
Wow, so surprise, you're now the...
Surprise you've been named, or they may name you as the second or third, and 10 years later, you've become the first.
Because someone else is
attrition
gone or they can't find them.
Exactly right.
Wow.
You are not obligated, if you are named, it's worth knowing, you are not obligated to accept the appointment. If you accept the appointment, you are going to be obligated to do the job right, and you can't just change your mind after you accept it and decide you want to resign, because you can't leave a vacuum. You basically have to take steps to get a successor before you're relieved. So you have a decision to make, but you do have the right, if something falls on your lap, or if you said yes at one time and 10 years later things have changed, you do have the right to decline.
So what about somebody that passes or doesn't, they've named somebody and that person is deceased and there's no one else. So what happens in the vacuum if there's no agent? Does the state step in and become the person that processes people's estate?
If you have an estate planning document that applies and it names somebody and that person either declines or has died or for whatever reason the people you name can't do it, there are a couple of different approaches you can use. One is the adult beneficiaries can agree on a trust company, a licensed company that is able to do these kinds of things. If they can agree on it, the court will appoint that person. If they can also select somebody, and subject to court approval, the court can appoint that person.
So there's people that are, they think they're professional fiduciaries. Is that the right term, or is that something
Yes,
else?
there are professional fiduciaries. There are a number of people who can serve. Individuals can serve, But if you do it more often than whatever a fairly low number over a period of time, you have to be licensed. You have to become licensed to serve. If you do it just once or twice, you don't necessarily have to be licensed to do it. And there are a number of good professional fiduciaries, individuals, small companies, small operations run by individuals or with staff. There are some law firms and lawyers that do it. Banks, financial institutions will have trust departments that are capable of doing it. Who you choose or what organization you choose is in large part dictated by where you are, where the services need to be performed, and what the needs of it are. If you've got very esoteric, let's say you happen to own forest land. Well, some of the very best management skills for forest land, which is not a typical management skill, are in large fiduciary institutions, banks and financial companies. If, on the other hand, what you really have is an estate that you're going to parcel out on a discretionary basis to 3 people who are in college and you're going to be coming in and asking for money, well, that's going to be more soft side than hard side, and you're going to want somebody that is going to take the time and be willing to listen and also be willing to say no and essentially be able to make the kind of decisions you probably would have made if you had lived.
So for people that are listening that haven't delved in this at all, have just kind of put it away, just avoiding, how do they get started? What's the first thing they need to do? Do they have to get their documentation together? Do I make a list of where my bank accounts are? And what is it? How do they get started?
Well, it is a good idea to sit down and make a list of your assets. It's also a good idea to sit down and take a look at what your obligations are. I don't necessarily mean your debts. You have a different list if you have 3 young children than if you have 3 grown children. Okay? So part of your estate planning, if you have 3 young children, is what's going to happen to my kids?
So do you appoint a guardian in there too?
Well,
is that a piece of what you do?
Sometimes people are uncomfortable when they learn that the state is the ultimate parent. Okay, in the sense that when you die, you can leave written instructions. You can make an appointment. You can make a nomination, if you will, of a guardian of the person or the estate, or the same person can be both, for an individual. But that is not an automatic. Okay, that has to be approved by the court. And ultimately the court has to make a decision whether the person you selected meets the criteria. Now, I can tell you that unless that person is pretty glaringly deficient, courts are inclined to trust the judgment of parents. Okay, and so unless there's some really good reason not to appoint somebody, by and large, they're going to appoint the person the parents have selected, particularly if it's a recent appointment and the person is capable and willing to do it. But ultimately, the court has the power to appoint or not appoint. The courts have the ultimate power to decide what happens to your kids in terms of who has the legal authority after you die.
Wow, that is scary. I mean, to me, I didn't realize that. So just, I'm curious now. So I'm a young parent. I appoint my sister to be the legal guardian of my child, and I pass, and there's no husband, whatever. Does my sister get my child automatically until the court decides, or does the court have her in a holding place someplace?
Generally, your sister gets your child, because
Okay.
the fact of the matter is that if you're of an age that you've got a young child, your sister's been involved. Either she got involved when the police called about the car accident that took your life, or you've got a debilitating illness and you've seen this coming and she's involved.
Got it.
And at that point in time, the courts aren't aware of it, the police aren't aware of it. Nobody wants to take your child. This isn't something where they're just waiting to pounce
Right.
at all. That child is going to go home with you, and you're going to do the best you can to care for that child. But eventually, you're going to have to get appointed. And in that circumstance, if the sister doesn't have a felony record, doesn't have issues, the kinds of issues that would cause any reasonable person concern, the judges who do this, and particularly in our bench, we're very lucky, they're caring people, they're good people. They're looking for the best interest of the child. That is the standard. And there's an assumption that the parents have a pretty good idea what's in the best interest of the child. And so it's not like they're looking for reasons to say no. But at the same time, you want to make sure that there are resources in place to make sure that children are cared for. And it's not a bad idea to have somebody you can go to if for some reason it doesn't appear to be the case.
Wow. So I just wanted to mention a website that I shared with you called getyourtogether.com
Yeah.
is the name of it for our viewing audience. It's gyst.com, and it has a checklist, because I think part of it is the very practical. I'm an executor, and I need to know from my person well, where do you have bank accounts, and what's the pass key for, where do you keep the key for your safety deposit box, and do you have a lock in, is there a safe in your house, and all those kinds of very practical things. I know people have agreed to do things, but they don't have the hard information to be able to execute it after the person has passed. So, I mean, that's a checklist and a place to find some people.
It's even more important now than ever. We used to give our clients a binder, and at the front of that binder was a sheet where people could list this kind of information. It's always been important. 20 years ago, we would tell a client that came in and said, my brother just passed away, it was unexpected, I'm the executor, I'm the trustee, I don't know where the assets are, what do I do? 20 years ago, I would say, just watch the mailbox. You'll get a monthly bank statement, you'll get a bill, you'll get quarterly, you will get information, and you will find that information, and that will identify the assets for you. Today, that's not the case anymore. My bank statement comes to me electronically. If you don't have the password for my email account, and if you don't have the password for my online banking, you don't have any idea where my account is or what the situation is. So it's very important. They always tell you, never write down your passwords. The computer folks always tell you, never write down your passwords.
Security breach.
But the bottom line is, if you don't write them down somewhere, and if people don't know where to find that, it's going to be very difficult, because you try going to Facebook or to a bank and telling them your brother passed away and you need to get this information to feed their kids, they're going to say, gosh, I'm really sorry about this. But we cannot act without authority.
Wow. Well, in 10 seconds or less, do you have a message of encouragement for people to start estate planning?
Yes, I do. And that is, sometimes people are afraid to start estate planning because they're worried that that somehow their death will be more imminent if they actually admit that it's someday going to happen. And I can tell you, in 43 years of practicing law, I never saw that happen. You will feel better. It's a gift to yourself, and it's also a gift to your children, to your heirs, to the people you care about, to do the planning. And it's not that hard to do.
Well, thank you, Claude, so much. And as I mentioned to you, this is our Book of Living Love. And if there's somebody that you would like to remember that's passed, we invite you to put the name of somebody you'd like to remember. And I would like to thank TVSB. I'd like to thank my crew, Elliot Jacobson, Michael Nicholson, and Ken Baxter. I want to encourage you all to take action, to consider how you want to live your life, and you can live in grace if you take action to plan ahead. We're grateful for our chance to be together. Live each day of your life. Thanks.